I met a lawyer, not a doctor, inside that compound, just for them to arrange what they wanted to arrange. I was so sure when I hear say the 26 years was having a will. Me as a father, I'm 50, 60 years of age now. I do not have something like that. I never think of say writing my will. 26 years old boy was writing a will, which is capital no. So they have to collaborate with the lawyer to maybe to put his hand into many things that is not right. 26 years of age, now thinking of have his own will. And Mohbad is a kind of person that he can never think or say he want to use hand to stab it. So instead of that, he will sign. Because he's dead, they have to call lawyer to do their own mathematics inside. It's so God that want to expose them. So
hello everyone, you're welcome back to another episode of The Legal Critic. How are you guys doing? Okay, today I'll be bringing you another amazing, enlightening topic. If you know you've not subscribed to my YouTube channel, please do well to subscribe and don't forget to turn on the notification post so you'll be the first to know whenever I create any enlightening video. Alright, in today's video, I'll be talking about a very important and crucial topic in our society today. Basically, I'm going to be talking about the constitutional required age for a person to be before he or she is eligible to make a will. Simply put, at what age can a person make a will in Nigeria? Stay tuned as I bring to you this amazing video. A will is a document that speaks after the death of the person making the will. This document ensures that the properties of the person making the will is being shared among people as he desires. With a will, you can control your affairs even when you're no longer alive. You can also give instructions on how your affairs or your properties or your things should be carried out even when you're dead. Now, when I mean document, I mean the sum total of your wishes being reflected in the document and not just a mere written paper. Will in Nigeria has been in existence since 1837. The first feature of a will is that it is testamentary. What that means is that it is valid or it speaks after the death of the person making the will. A will cannot be valid when the person called the testator who made the will is still alive. So it's only valid when the person is dead. Another important feature of a will is that it is amendable. Like you can amend will as time goes on as long as you're still alive. The person making a will can from time to time amend his or her will. I used to have a client back then that has 5 children, and each time any of them comes and offends him, he comes back to the office and amend 1 or 2 paragraphs of the will. So as long as you are alive, you can always amend the will, and the last amendment you made will be the valid will. While the third feature of a will is that it's made voluntarily. It cannot be made under duress. It cannot be made under any undue influence of anyone. So a will must be made voluntarily by the person making the will. Now, there are some documents that disposes of properties from one person to another that might look like a will, but they are not will. The first one is a nomination. A nomination is like a directive given to a person. For instance, if I'm maybe a CEO, I give a directive that if I die, the money in my account, the money in my company should be given to another person. Nomination can only occur when it has to do with funds, when it has to do with cash. It does not have any validity when it has to do with properties. So you can actually say, I nominate this person to take my money or to be in charge of my money or to inherit my money when I'm no longer alive. So that is not a will, that is called nomination. The second one is a gift. A gift has some features of a will. However, one of the differences between a gift and a will is that a gift starts taking effect while the person making the gift is still alive. So a gift is just me disposing my property. It might be money, it might be property, it might be clothing, it might be anything to another person. And immediately I sign that deed of gift, I relinquish those properties and it becomes the property of the other person. So as an individual, if I feel like if I write a will, my family is very troublesome, they might have issues maybe with the way I dispose the property to the beneficiaries or to my family members, I will simply do a deed of gift and gift the properties to the ones I desire. In that way, it will take effect while I'm still alive and nobody will be able to challenge that deed of gift. Another one is called donations. Donation is a disposition of a property in contemplation of a death. For instance, if I'm sick with a terminal disease and I feel like I'm going to die soon, then I dispose all my asset or property to another person, and immediately I dispose of that property, I lose control of that property and it goes to the third person. However, a disposition is unique in the sense that it is only in contemplation of death. So if I eventually do not die, my property comes back to me. So those are different types of disposition of properties that might seem like a will but not a will. There are certain procedures that are obtainable in writing a will in Nigeria. When writing a will in Nigeria, consideration must be made as to the existing law that govern will making in Nigeria. There are two major laws that govern will making in Nigeria. The first one is the will laws of various states, while the second one is the administration of estate laws of various states, or administration of estate acts. Now, these laws must be put into consideration whenever you're drafting a will. There are certain conditions and requirements for obtaining or making a valid will. The first requirement is age. A person making a will must have obtained the required constitutional age of making a will. The required constitutional age of making a will or being an adult is 18 years. So once you're 18 and maybe life happened to you so fast, you have some properties, you can actually make a will and dispose your property. And as time goes by, you keep changing it. Even if you're not married, you can make the will and give it to your siblings. When you get married and maybe you keep acquiring more properties, you can always amend your will. The second requirement of making a valid will is sound mind. The person must have the requisite mental capacity. The person must be free from any intoxication or undue influence. The person must understand, as at the time making a will, that he or she is making a will. Must recall and know all the properties or assets that belongs to he or her. And also know that actually I'm giving out this will to these beneficiaries, know the number of beneficiaries and the extent at which he or she is giving that will. Once you have that mental stability and mental capacity, then you can make a will. Otherwise, the will not be valid and might be vitiated or maybe questioned in courts. Another requirement for making a valid will is that the will must be in writing. Now, an oral will is as good as no will at all. It might either be handwritten or typed, but I would advise that you type and print a will. When a will is not in writing, in fact, there is no will in law. So a will must be in writing. And based on the normal modern standard, it should be typed and printed. Another requirement is that a will must be executed. Now, the word execution sounds so big, but it simply means that a will must be signed. Signature here has to do with, it can be mark or it can be any thumbprint, it can be even your signature. So it must be signed and in presence of two witnesses. What the witness does in law is what we call attestation, to attest to the fact that he or she was present when you made the will. However, your witness must not be a beneficiary to the will. The only exception to that rule is that if that your witness that is also a beneficiary is your spouse and the property or the asset in which you bequeathed to the beneficiary is a matrimonial asset. There are other exceptions, but this is just the major exception. So the witness can only be a beneficiary in that situation. Now, another important requirement is that a will must be lodged in the registry. After making a will, you must register it at the probate registry. I think the probate registry usually is in the high courts of the states in Nigeria. When you go to the high court, there is a section called the probate registry. That's where you go and lodge your will. the reason why you go register that will is to clarify all forms of doubt and give it authentication, make it authentic. So if you do not register a will after maybe writing a will at the probate, it's as good as not making a valid will. Also, for a will to be valid, it must have at least 2 executors. Now, in a will, we have the testator. The testator is the person that makes the will. The second person is the beneficiary. The beneficiary is the person that benefits from the will. The third group of people are the witnesses. That's the witnesses. They attest to the fact that they were there when the will was made. And the fourth group of people are the what? Executors. These executors see to it that the desires of the testator are being carried out in the same way as stipulated in the will. So their major function or major work is like a supervisor to oversee that the desires of the testator is being carried out or are being carried out, as the case may be, in the will. Now, when making a will, there are different contents of the will. Like I said before, a will is not just any document, but is a sum total of the desires of a person being reflected in that document. Now, some of the contents of a will is first the details of the testator. That's the person making the will, his name and probably state of origin and all that. Then the details of the beneficiaries and the mode at which the assets in the will are being distributed. Also, the details of the witnesses. Then the list of assets, e.g. if it's a real estate, pension fund, jewelry, funds in an account, shares, you have to list them and distribute them accordingly. We also have the details of the executors too. They are also very important. Now, the reason for making this video, like I said before, is a video of Mohbad's father saying that he is almost 60, he hasn't made a will, while his son, who is 20 plus, made a will. Well, from this video, you will understand that if Mohbad really made that will, and all the valid requirements are being reflected in that will, then that will is valid, irrespective of the age that he is. This narrative of always assuming that it is only when someone is old and dying or maybe very sick or something, that is when the person should make a will. This is 2024, it should stop. A will can be amended. So if you're young and life happened to you so fast, you can make a will. Gone are those days when wills are for just the old people, as nobody knows tomorrow. If you have properties and you're 18 years and above, go ahead and make a will. What Mohbad's father or the people involved should be talking about is if those will met the requirements of the law, if those wills are valid, if he was of sound mind, if there was undue influence, if he actually signed those wills. Those are the things they should be talking about, and not him saying that because he is young, then he shouldn't have made a will, or he's doubting it based on the fact that he is young and then contemplate to make a will. This is 2024, guys. So once you have a property, irrespective of your age, go ahead and make a will. I hope this video enlightened you more about will. So tell me in the comment section if you're going to resolve in making a will. It doesn't mean you're going to die. It just means you're planning yourself accordingly. Like I said before, you can always amend as life happens to you. So I want to know in the comment section down below if you're going to make a will. But before then, do have a great time. See you on my next video. Bye.